Good morning. My name is Robin Miller, and I'm Corporate and Tax Counsel for Pro Bono Partnership of Atlanta. Today's webcast is Social Enterprise Part 2, What Can 501c3 Organizations Do? This is a continuation from the previous webcast we had last month, which was Social Enterprise Part 1, and that involved discussing various different types of entities that are useful when creating a social enterprise. That webcast can be found on our website at pbpatl.org if you're interested in watching. I will do a little bit of an overview of what we discussed, but it will be very brief. But before we get into the substance of our presentation today, let's go over the mission of Pro Bono Partnership of Atlanta, which is to provide free legal services to small nonprofits that serve low-income or disadvantaged individuals in and around the metro Atlanta area. We match eligible organizations with volunteer attorneys from leading corporations and law firms who can assist those clients with their business legal needs. To be eligible for Pro Bono Partnership of Atlanta services, there's a slide here that walks you through all the eligibility requirements, but you need to be an existing 501c3 nonprofit corporation. You need to be located in the greater metro Atlanta area, and when we consider greater metro Atlanta, that's a pretty wide berth. It includes as far as Macon to Dahlonega and so on. You have to serve low-income or disadvantaged individuals, and that's important, and be unable to afford legal services. If you think you might qualify as a client, please be sure to visit our website. The email address or the website address is right there in that slide, and complete our request for legal assistance, which can be found under our nonprofit tab. We also do these monthly webinars every month, so they're available to anyone who's interested in participating. And we have hundreds of resources on our website on various different topics for nonprofits located in Georgia. So if you have any questions, you can always check there for more information. Our next slide is our standard legal information slide, which basically says that the information I'm providing to you today is general advice, not specific legal advice, and you should be sure to consult an attorney for any specific legal advice that you might need. Also, this information is copyrighted and is owned by Pro Bono Partnership of Atlanta. So now let's turn to the substance of our materials today. I want to start out with a brief summary of what we discussed in Part 1. We started out with the definition of social enterprise. I actually put up two different definitions, both very similar, but kind of a little different wording, a little different approach. I then discussed the various different corporate structures that are viable and may be appropriate for different social enterprise organizations, including discussing for-profit businesses, L3Cs, public benefit corporations, social benefit corporations. And then I really briefly talked about 501c3 nonprofit corporations because I really reserved that discussion for today's webcast. So some of these structures are better than others depending on the type and goals of the social enterprise. And that's really important because each structure has its own advantages and disadvantages. And it really depends on that social enterprise and what it's trying to accomplish, which structure might fit best for them. Also, some of these structures are not currently available in the state of Georgia. For instance, L3Cs, public benefit corporations, and social benefit corporations do not exist in the state of Georgia at this time. Hopefully next year at this time, public benefit corporations will be available in the state of Georgia. We'll have to see how that plays out. Let's go back and talk for a minute about what is a social enterprise, just to bring everyone back to the same page and make sure we're all moving forward together. So a social enterprise involves the use of market-based strategies to solve a social problem. In other words, you're selling a good or service of some kind, and you're using that income for good. It can also be that that good or service can be the good that you're serving or providing, but usually it's that you're selling a good or service and then using the income generated therefrom for doing some kind of social good. These can be structured, as I mentioned before, as a nonprofit, as a for-profit. They can be exempt, tax exempt, or not. The focus of today and the rest of what I'm going to talk about is for 501 organizations, nonprofit corporations that are recognized as 501c3 organizations by the Internal Revenue Service, and how those organizations can do social enterprise activities within the confines of their structure. Turning now to the next slide, slide 7. This slide I had up in the last presentation, but I think it's a really good starting point. Considerations for conducting social enterprise activities. Again, social enterprise activities involve the sale of good or service, and those goods or services may or may not be in furtherance of your tax-exempt or charitable purposes or mission. And so that's one of the first questions you need to ask is this activity that you want to conduct, this social enterprise activity, does it actually further your mission? And I don't mean by that it provides money for you to then further your mission or to provide additional programming, but that the activity itself is part of your charitable programming. And that's a really important distinction. Under the 501c3 code and regulations, there's an operational test that all 501c3 organizations must meet. And that is that the organization's activities must further its charitable purpose. You'll notice that in the slide, the exclusively is in parentheses because the statute says exclusively. But for many years now, it's been interpreted to be primarily. So your activities must primarily further your charitable purpose. And if it doesn't, then there's specific consequences, including loss of tax exemption or taxation. And we're going to talk about both of those. So jeopardizing your tax-exempt status. So 501c3 organizations cannot engage in unrelated business activities, which would be sale of goods or services, that are substantial in relation to their charitable purpose. But what does that mean? The two words here that are critical is that it's unrelated to your mission and that it's substantial in conjunction with what you're doing for your charitable purpose. So again, like I said, making money for the organization doesn't make it related. It actually has to be an activity that is related and reaching towards your goals and your mission's goals. And substantial, well, the IRS never likes bright line tests. There really is no specific definition for what constitutes substantial. I get that question all the time, and unfortunately, I wish I could say, yes, it's this percentage, but there is no such bright line test. You need to start being wary of it when you're getting over, 15, 20% of your activities are this activity, and need to be thinking about other options and things to do with that activity. I want to give you a really good concrete example because I feel like I've been talking sort of amorphically. In the 1940s, New York University School of Law purchased the Mueller Spaghetti Factory. They thought, this is great. We'll have all this income from the spaghetti factory. We can use that income to fund the law school, and we'll be set. Well, in addition, they could charge 15% loss because they don't have to pay income tax and still make a killing. And probably put some of the other spaghetti factories in New York out of business. Well, in the 1940s, there were a lot of Italian families that owned spaghetti factories that were not happy with this move because they couldn't compete. And so there ended up being hearings in Congress. And what resulted from those hearings was what is now known as the unrelated business taxable income rules and code section for 501c3 organizations. And we're going to spend some time going over those rules. But the key thing to take away from this situation was at the end of the day, what you had was this very large spaghetti factory and a really small law school. And you pretty much had the tail wagging the dog. And basically they had to sell the spaghetti factory because they couldn't control it within the 501c3 organization. They had more than a substantial amount of their activities going towards running a spaghetti factory as opposed to running an educational law school. And so that's sort of a big picture example to be thinking about in the back of your mind as we go forward and talk through some other examples and situations. If you turn now to slide 9, let's talk about what is unrelated business taxable income. Now, I will say this. You'll hear it as UBIT, as UBI, as UBTI, and they're all basically the same thing. It's just a different way of saying unrelated business income or unrelated business taxable income or unrelated business income tax. So don't be confused by the different terminology. So the test is basically you have to meet 3 specific things. If any one of these things don't exist, then the activity is not generating unrelated business taxable income. So it has to be a trade or a business. It has to be an activity that's carried on for the production of income from the sale of goods or services. If you don't have a trade or business, an example might be, let's say you do an annual gala, or once a year you hold a golf tournament. You're not a golf course, and you're not regularly carrying on golfing activities. You're doing this once a year. That's not a trade or a business for you. It might be for someone else, but it's not for you. It also needs to be regularly carried on. So you have to look at how often you're doing this. And it's not just regularity, but it's also continuity. So you have to think about it in the context of what you're selling. If you're selling holiday cards are usually sold from August to December. Well, if you're selling them from that same period of time, then it's regularly carried on. It might not be all year round, but that's when the commercial activity is being conducted in the for-profit world. And that's really the consideration you have to think about. How much time is being spent throughout the year towards this activity, or is it within the right amount of time that would be done by a for-profit business? And then it also has to be not substantially related to your mission. And by that means there's no causal relationship to your charitable purpose. Again, I'll say this a million times, but just because it raises money for your organization does not make it causally related. The activity itself must be related. Many of the social enterprise activities that we hear about and that a lot of C3 organizations want to conduct meet this test. They meet the unrelated business taxable income test. And so for 501c3s conducting such activities, they really need to make sure that the activity meets a modification or an exclusion to the rule, so that it becomes not unrelated business income taxable. So there's a whole, and I could spend days talking about all these exclusions and modifications and so on, so I can't do that. We're going to go over some of them in a minute or two, but I'm going to do it at a very high level. But needless to say, if you meet one of the exclusions or exceptions or modifications to the unrelated business taxable income rules, then it's not considered that, and you can conduct that activity. Or if you have a social enterprise activity and it doesn't meet one of those exceptions, then you just pay the income tax, but you have to make sure that it's not a substantial part of your overall activity. So it's okay to have some UBTI. You just don't want to have a substantial amount. So your choices are so far to find an exclusion, exception, or modification, or to conduct the activity and not do it as a substantial part of your activities. Or if it is substantial, to spin it off and do something else, put it in a separate entity, but still get benefit from it. And we'll talk about that as well. So now let's talk about some of these modifications and exclusions. And like I said, I could spend a lot of time on these, so I'm going to go through these at a very high level, but there's lots of case law out on each of these. There's regulations on them, and some of them are somewhat complicated. Let's start with one of the most common, which is volunteers. So if substantially all the work for this activity is being conducted by volunteers, then it's not considered UBTI. And the reason for that is basically the activity wouldn't succeed without the use of volunteers. So you're really not competing with a comparable for-profit business, because if you had to pay your employees to do the work and they were employees, you wouldn't make any money at it. So then the question is, okay, well, and I'll give you some examples. The monthly car wash, where you've got all your volunteers coming out to do the car wash. Or Girl Scout cookie sales. Girl Scout cookies are sold by Girl Scouts and they are volunteers. The Junior League resale shop. And that's not going to be true of all thrift stores, but that's true of the Junior League. They use only volunteers for their resale store. So those are some examples where it's mostly volunteers doing the work. And well, so when I say mostly volunteers or substantially all, what does that mean? Well, there's a ruling that says 77% is not good enough. And likely 85% or more of the activities being performed by volunteers will qualify for this exception. So it's a very high level. So it really needs to be substantially all volunteer activity. Training program. I'm going to spend a whole slide on training programs, but I did want to put it on this slide because I wanted to kind of give you a summary of all of them here. So we'll hold off on talking about training programs, but it's actually a common mechanism for a number of our clients and other C3 organizations that we're familiar with for conducting social enterprise activities. The contributed property exception. Well, that is your thrift store or anything that's donated to you that you then turn around and sell. The most common is going to be a thrift store or Goodwill or other similar circumstances. But if you have things donated to you and then you turn around and sell them, that is an exception to the rule. And it's because you only have that property because somebody gave it to you. You're not really running a business of purchasing inventory and then selling it. I want to spend a few minutes on passive income because it's really the most common way when you get into a sophisticated scenario that you can obtain, and it's one of the sort of four options or several of the four options that I'm going to talk about a little later for receiving income through a social enterprise that won't generate unrelated business taxable income. Dividends, interest, annuities, and royalties is what we're talking about. So if you have a bank account and you get interest off that bank account, or you own stock as a C3 organization, and you get a dividend from owning that stock, that's passive income. The organization, the C3 itself, is not actually conducting any kind of business, for-profit business activity or activity unrelated to its mission. It's simply holding ownership in another company, or it's got its money located somewhere and it's getting interest on that. It's incredibly passive. It's not doing anything to earn that money other than owning the shares and not really being involved in the day-to-day activities. So that is an exception. In addition, royalties is another very common exception. And in the case of royalties, basically you are, as a C3, providing your name and logo to a for-profit business who then uses it on its products or goods or services, and you get a certain amount as a result of that. It can be a total lump sum, it can be a per unit amount. There's various different ways of making that happen. We'll talk about that in a few minutes a little further. But that situation also is passive. You're simply lending your intellectual property to that organization to be used. You're making sure they're using it in a quality manner and in a way that you're comfortable with, but you're not providing any specific services associated with that. And that's important because a lot of royalty arrangements, and we'll get into this a little more, if they want the charity to perform services in conjunction with that, now you're active. And now you're not sitting on the sidelines and simply allowing use of something. You're actively doing something to earn that income. And that takes it out of the exception to the rule or exclusion. We're going to talk more specifically about cause marketing and for-profit subsidiaries, but I've listed them there because they fall under this category. Rents from real property. If you own the property outright and you rent it out and you don't provide any services other than sort of the traditional, maybe there's janitorial services, or maybe you make sure that the lighting is on in the parking lot and that the facilities are clean, and you don't provide any other services. For instance, you do not provide maybe a central receptionist. You do not provide a copying service within the building where people can come and use the copying services that you're providing. You're not providing any additional services and you own the building, then those rents would be considered passive, not really any different from interest from a bank account. The sale of property is really complicated. I've listed it here, but I'm really not going to go into it because it doesn't apply to inventory or property held in the ordinary course of business. And since we're talking about social enterprises where you're talking about the sale of goods or services, if that would be inventory in your business, and so it really probably won't apply in this circumstance, but I wanted to keep it on the slide and list it. The next slide is sort of a summary of some really good questions to ask yourself as an organization as you start to engage in these kinds of activities, to help you think about whether or not any of these activities you may be thinking about conducting would be unrelated business taxable income. So if you're selling merchandise or property, what's being sold? Is it donated? Do you have a logo on it, which is another exception to the rule in certain circumstances? Who is selling the items and who's purchasing the items? Are the items being sold by volunteers? And is it all being managed by volunteers? And what services are being provided? So in the royalty arrangement, are services being provided? In the rental scenario, are services being provided? And then who is providing those? So those are some really good questions to think about as you're analyzing these situations. And then, of course, there's some additional questions for rental property as well. But if you are seriously considering one of these activities, I do highly recommend that you get competent legal advice in this area. The next slide simply has a couple of our resources, as I mentioned at the beginning of our presentation, that we have a number of resources on our website, and these two deal specifically, or the webcast deals specifically with unrelated business income, and then there's several articles on the subject as well. So now let's spend a few minutes talking about some creative solutions for nonprofit organizations. Some approaches that will potentially avoid the loss of tax-exempt status and unrelated business taxable income for 501c3 organizations. And I've listed 4 things that we're going to go through. Some are more geared towards social enterprise specific activities than others, but I think it's important to mention all of them because they all could be. So I'm going to talk about training programs, cause marketing, sponsorships, and for-profit subsidiaries. For each of these, I could easily spend 20 minutes talking about each one, or more. So again, this is a very condensed version of this scenario. For training programs, I highly recommend that you read our article that we have on our website on this topic. This next slide is chock full of information, and I really don't like to do that on a slide, but I wanted to try and summarize what was in that article as best as I could so that you could get more of a full picture. I want to work through a really clear example of a training program, which usually a lot of these training programs, of course, are work or job skills training programs. So one common example that we see a lot is food or culinary training as a job training program. And it can start different ways. How it actually comes up can be unique. But oftentimes we have clients who are trying to help people retool, or maybe who have been previously homeless and try to be sustainably homeful. And so how to figure out ways to give them training in a field that they could earn a living wage at. So food industry or culinary skills is often a common area. And it's important that be related. So if you are in the business of doing environmental education, you shouldn't be having a culinary school because that is not related to your mission. So it's usually organizations that are in the business of providing these kinds of services to their clients and doing that job retraining or helping people who've been previously homeless or currently are homeless. Excuse me. So the first 2 bullets are essential. And that is that there's a clear and distinct causal relationship between the worked activity and training of the individuals. And what does that mean? That means that these people are actually being trained. They're being trained on skills. And usually they're not just being trained on the specific skill of culinary arts, but also maybe there's some financial training, or there's some language training, or there's some other training, life skills training that's also going on in conjunction with the program. The scale of the training program cannot be larger than what's reasonably necessary to accomplish the charitable organization's purpose. So let's say you decide to have a culinary school. And really what, of course, what's the social enterprise activity there? Well, it's catering business or it's a restaurant. And so that's the social enterprise activity. You're selling goods or services. You've got either catering business where you're providing food to others, and that's a byproduct of the work that's being done in the training program, or it's a byproduct and it's a restaurant and people are learning restaurant skills and kitchen skills to be able to translate that into a job. But it can't be bigger than what's necessary for your trainees. And it also really has to be primarily conducted by trainees. So you can't have, let's say you've got 10 employees that are all doing the same work. 5 can't be trainees and 5 can be not trainees and simply employees. Trainees also, and I want to make this a really important point, if you're doing a training program like this and you have some kind of real good or service that you're selling, whether it be a catering business or a restaurant in this situation, you must treat your trainees as employees. You must pay them minimum wage and treat them as employees because they're working for you. And that's really important. And I'm not going to go into all the employment rules about that. Suffice it to say, we have plenty of information on our website to cover all these rules. And I highly suggest that you look at our website for that information under the resources tab and then under the employment tab. But my point is that you can't have equal number of trainees and non-trainees doing the same job. Now, of course, you're going to need non-trainees, supervisors who are teaching your trainees how to do this work. But it should only be sufficient to do the training and to teach them and to oversee the operations. But otherwise, it should all be trainees that are doing the work and that are in order to meet this training program exception. There's a whole series of bullet points below, and you need sort of some combination of those in addition to the 2 bullets above. And so I want to briefly sort of run through those. And some of this I've already actually talked about, integrated in what I've said. But it's important that the trainees are the primary employees, except for those providing supervision, that all work in the program is being conducted by those folks, that the work or employment in the program is transitional. And this is something I haven't talked about. There has to be a beginning and an end. Your trainees can't be there year after year after year. The goal is to train them and move them on. And it's really important to have actually a syllabus, a curriculum. What is your goal? What do you hope these people will learn over what period of time so that they graduate through your class and ultimately go out and find employment? And that's really critical. And if you can have that written down, that's a huge benefit should the IRS come and ask about your training program, is that you can show what your curriculum is and what they're learning over time, what skills they're gaining, and when in the process, and when they finish and graduate from the program. Then any net profits gained from this commercial activity or training program, of course, are going to be applied to your mission, which is, again, our social enterprise purpose, right? To raise money, to go back in and assist the mission. But at the same time, you're helping and conducting part of your mission in this program. But the sale of goods or services generally, the sale, having a restaurant or having a catering business in and of itself is not a charitable activity. So that's what makes this different. So now let's move on to cause marketing. Like I said, I could talk about these for a long time. Now let's move on to cause marketing. And what is it? Well, basically, it's where a for-profit business and a 501c3 nonprofit get together to encourage the C3's mission. It's a specific campaign or promotion, and I'm going to give you a real good example. Yoplait Yogurt, every October, has pink lids on their yogurts. And they also have the logo of a very well-known cancer organization on the container of the yogurt, and it says that if you take your lid and submit it, 10 cents for every lid will go to this cancer organization. It's a very successful program. And what that is that's a cause marketing relationship. Basically, Company A has entered into a royalty arrangement with Charity B. And Charity B is giving Company A its name and logo in exchange for 10 cents for every pink lid that's sent in. Sometimes there are maximums on those amounts, and sometimes there are minimums. Usually it's a maximum. And that needs to be stated right on the label of the product. Now, Charity B is not selling products, right? They're simply lending their name and logo to a product that's already being sold by a for-profit business. So it's sort of a way to conduct a social enterprise without conducting it, and that you're not in the business, the charity is not in the business of selling goods or services, but it's connecting itself with the sale of goods or services to bring in more money to the organization. And it's doing it in a way that's passive activity. The cancer organization does not go out and promote people going out and buying Yoplait yogurt. They don't constantly send out social media every other minute about it in that month of October. They don't put out big, huge ads. They don't advertise the sale of the product. They're not conducting any services on behalf of this. They're simply lending their name and logo, and they get a return, a benefit in return, which makes it a royalty passive arrangement, which is not generating unrelated business income. So that's a great way to sort of be in the social enterprise realm while being very safely not in it at the same time. All right, let's spend a few minutes on qualified corporate sponsorship, because this is an area that is fraught with UBI potential. And so a specific section of the code was added in relatively not that long ago, addressing this issue. So you have to start from the standpoint that advertising is unrelated business, generates unrelated business taxable income. So if you have a banner on your website and you sell it, that banner space, to businesses to advertise their products, talk about sales, maybe it's a grocery store, local grocery store, and they list their sales of the week on the banner, and you get revenue from that, that is advertising. Well, there's something called the bowl games. There's the Capital One Bowl, the Tostito Bowl. There's lots of different bowl games. And it became a huge issue for the bowl games. And they wanted clarity, because they felt just because I called it the Capital One Bowl does not mean that it is advertising. I'm simply recognizing my sponsor. And so eventually rules, a section of the Internal Revenue Code was created to address this issue, and regulations were put into place, and they're called the Qualified Corporate Sponsorship Rules. And so the key there is to not advertise, but to simply acknowledge. And so what is an acknowledgement? Well, on your banner, let's say your grocery store is a sponsor. Well, you can list their name, you can list their logo, you can list their website, you can list their address and their phone number. And you can even say, thank you, grocery store, for being our wonderful sponsor. You can't say, you should shop at grocery store because they're wonderful and they have great products. You can't say, grocery store's having a sale this week on apples. You can't say that grocery store's prices are better than grocery store B. You can't say that grocery store A is higher quality than grocery store B. So basically, you can acknowledge them as a sponsor, but you can't do anything qualitatively or quantitatively to support that business. Otherwise, it becomes advertising. And if it's advertising, you're paying income tax on those revenues. If it's not, and it's just a sponsorship, it's not unrelated business taxable income. So there's one other piece to it, and that is that you can't give us a return benefit, a substantial benefit in return to the entity. So like grocery store A, they can't get any kind of return benefit from you by having that banner up and paying that amount. Maybe you have a big gala every year and you want to give them a table at your gala. You need to be careful that they're not getting anything substantial in return as part of the rules. And it can't exceed more than 2% of the value of the sponsorship for the year. If it is, then that becomes something that needs to be taken out as what's called a quid pro quo. And so they're getting something back in return. And so they don't get the benefit of that as part of their sponsorship amount. And if most of what they're getting is something back in return, then it's really not a sponsorship at all. So if you're thinking about connecting yourself with an organization as part of for-profit business as part of your social enterprise activity, but you don't want to conduct the activity yourself. This is another way to sort of get some income by recognizing your sponsors and being joint sponsors together. And there's a lot of businesses out there that want to be considered the sponsor of certain nonprofits because it gives them greater visibility and people might be more likely to go to that store as a result. The last one I want to talk about, which is sort of the most sophisticated and the most complex, is for-profit subsidiaries. So let's say you've got that culinary activity going on, and maybe it's gotten so big and so popular that it's really no longer just a training program. So you might need to, and it might be getting to be substantial in amount so that it could threaten your tax-exempt status. You might need to spin it off into a for-profit subsidiary. So I'll give you a really good example that I used in part one. In part one, I talked about a wonderful Atlanta organization called Open Hand. And Open Hand is a for-profit taxable subsidiary that it owns. It owns all the stock of that subsidiary, and it's called Good Measure Meals. And Good Measure Meals is a catering business. And they sell food, although I see their trucks everywhere in Atlanta. And it's good food, too. I will say that. What they did was they said, okay, we're going to create a for-profit subsidiary to run this catering business because it's really not a training program. We provide meals to the poor and those that are homebound, and that's what we're going to keep doing. And we're not really in the business. Our mission is not in the business of training people in job skills. So that's our mission. So, but they have this kitchen, and they decided to create the opportunity to make money off of this kitchen that's not always being used. So to do that, and this is very complicated, so you really need legal advice if you're going to enter into one of these kinds of arrangements. There has to be separation between the nonprofit and the for-profit. So in the case of Good Measure Meals, they hired a chef to run their catering business. They hired people that are in the restaurant business or in the catering business to run those operations. And there's a separation between the charity and the for-profit. You can have a little bit of overlap, a little bit of director, officer, and employee overlap, but you really need to have them separate and distinct. Because otherwise what you have is the same situation you had with NYU and the spaghetti factory, where it was all in one entity and they were operating the spaghetti factory. So you never want the C3 to be considered to be operating this for-profit business. You want it to be separate. You also have to have arm's length transactions. So if, for instance, and I don't know the actual circumstances here, but I'm surmising that if Good Measure Meals is using the kitchen that's owned by Open Hand, that there's an arm's length transaction for that activity, and they're paying for the use of that kitchen at fair market value. So there's a lot of separation that needs to occur. And then the reason it's not unrelated business taxable income is because it's not any different than owning stock in some company like IBM. Or Coca-Cola. If you just own the stock and you passively get a dividend from that entity, then it's passive income and it meets one of the exceptions. So in the for-profit subsidiary that you own, the C3 is simply getting a dividend from that entity at the end of the year or however often it's appropriate considering the activity in the business itself. But they're not combined. It's one of the more complicated approaches, but it's a great way to have a social enterprise activity and for it not to jeopardize your tax-exempt status or to generate unrelated business income, but still to generate significant revenues for the nonprofit organization. So with that, I want to really briefly mention that there are other complex creative solutions for nonprofits that I'm not touching on today. These are really complex and sophisticated approaches. Partnerships with for-profit entities. There is case law going all the way to the Supreme Court on how to do this and how to do it properly. It's complex. Do not enter into this without getting proper legal advice, but there are ways to do that. L3Cs and separate public benefit corporations are available in other states. They're not available in Georgia, so I'm not going to touch on those. Not very many states have L3C statutes because they were really devised to help private foundations give program-related investments, and most states have figured out that it's not necessary, so they have not enacted those statutes. Finally, to sort of summarize, some ways to mitigate your risks if you're going to engage in a social enterprise activity. One, make sure your purpose as a mission or your organization is broad enough to include this activity that you plan to conduct, if that's possible, if it fits within your charitable mission. Two, target the activity so that it's not regularly carried out. Make sure it's a limited time scope activity so that it never meets the regularly carried on standard. Three, generate that revenue. Try and meet one of those exclusions or modifications so that it, dividends, interest, rent, royalties, volunteer labor, donated merchandise, all the things, training program, all the things that we've talked about today. Or use that taxable subsidiary when the substantial bar, when you're getting close to hitting that substantial bar, or when you're not even sort of getting close, but close enough that it'd be better to kind of separate it out. Hopefully this webcast has provided you with some insights as to how 501c3 organizations can conduct social enterprise type activities, and that you've learned something from this today. We have more resources, as I've said, on our website. And with that, are there any questions? Thank you.